This is Melissa Zambri, and what a privilege for our firm to be here and to be partnering with NYSRA. We were thrilled to do the webinar on Monday, and today we're kind of going to pick it up and talk a little bit less about structure and corporate issues and a little bit more about some of the subtle nuances of compliance when you start to talk about forming or working with or joint venturing or any of those options that you have with an organization, particularly in a for-profit setting. Things that you have done traditionally as an agency, particularly when many of your, if you have multiple entities, many of them are service providers. It's a little bit different now that you may end up with this perhaps separate entity or this entity that is doing things very differently. We talked a lot about mission last time, and we've heard Loeb and Troper talk about mission. So we want to make sure that we at least highlight some of the issues that may come up as you start to think about how you're going to transform and what the future is going to look like and how you're going to get your individuals served. A little bit about our firm. I met some of you down in Poughkeepsie, but we're a statewide firm, so we have healthcare attorneys across the state, represent providers of all different types and sizes, but we're particularly proud to represent a number of providers in the developmental disability field, and it's something that we really like to consider ourselves partners with people who provide those very, very needed services, and we really admire what you do, and we also appreciate how difficult this particular issue is for many of you. And particularly when you're on the front lines and you're dealing with the families and you're dealing with the individuals and trying to get what is best for those individuals within a very new confine is very difficult. And so we're very, very, very privileged to be here today. I want to start a little bit and talk about privacy, because you're very used to certain things that you do within your organization, and now if you are going to end up with a for-profit entity that is not a provider necessarily of services, your agency as the licensed entity may be providing supported employment or other things in this agency, but now you are running the jewelry store, the cafe, the number of things that we've heard, some of the options. What does that mean? And what that means is that we're really in a situation where we have to be even more sensitive to privacy issues than we ever were before. In your organization now, obviously you have a minimum necessary standard, right? So certain people have certain job functions and they need to know certain information about the individuals that you serve. Once you venture out and you have this separate organization that's not a provider of services where people are working, it becomes a little bit different. And one of the difficulties will be educating your own staff, reminding your own staff, retraining your own staff that while you're going to have a very close affiliation with this business, and depending how you set it up, it may be more close or less close, but you're going to have a very close affiliation, but they are not a treatment provider, they are not a provider of services, and so there are reasons to really stop yourself at the door and think about what you're sharing with this organization, which for, in many ways, albeit while part perhaps of your system, it is a little bit more like people in a supported employment position at Price Chopper or Wegmans or from whatever part of the state you're at. It's a lot more like that, but it's not going to feel as much like that if it's so much affiliated with your organization. So how do we get information and do we want to get information regarding an individual's disability to the employer? So some questions that I've been asked. Well, Melissa, are we now going to be something called an organized healthcare arrangement? And that's what you see when you see it at your local hospital system, for example, where there are multiple entities and they all participate in joint activities and they're allowed to share information for their operations or for treatment. The problem is the likelihood is your for-profit business that's doing whatever service that you decide to do, whatever goods you decide to sell, is not a covered entity. Not providing treatment services may not be a licensed entity. You may set it up and decide you're going to provide licensed services in there, but from what I'm hearing, it's a little bit more like you're not going to do that. Your agency is still going to provide the services. So you're probably not able to get information back and forth that way. Is the disclosure for treatment? Well, probably not, because treatment disclosures, which you know from your privacy practices, are for the coordination or management of healthcare and related services, and it's by more than one healthcare provider. And you may have a separate business that doesn't provide any health care because it's a jewelry store, it's a cafe, it's any one of the number of things that you may be doing, it's manufacturing, and so it's not a treatment, so you can't just share information for treatment purposes. Okay, so what does that mean? Well, some of you have asked, well, am I a business associate? Because I've heard of them and we've got all these agreements in place and then we had to revise them all in 2013 and that was such a pain. What if maybe we're a business associate and therefore with my new for-profit business, if I want to share information about somebody's disability, I can do it that way? And the answer to that is likely not, because a business associate is somebody who uses the information on your agency's behalf. And here, you wouldn't be sharing it for that. For those purposes. They're not doing accreditation for you or any of the number of reasons that we use a business associate. They're not providing software services. So what does that end up meaning? That ends up meaning that if you have an individual that you're providing services to and you want to get information to your new organization, even though it's affiliated with you in any of the number of ways that Nick and Jim discussed, you need an authorization to get that information to the employing entity, even though it is somewhat related to you. And so I think that's very important. And how much information? Well, that's something that we can talk about later on. I will talk about a little bit about it. Maggie will talk about some labor and employment issues. And there's a lot of reasons that you want to make sure that that's kept to the minimum amount of information necessary if you need to share any information at all. When you do this authorization, if you do to share information, and I know some of you who have dealt with perhaps apartments and those types of things are familiar with this idea, and you should take this back to some of this stuff. If you want to take it back to your agency on a more broader basis, please do. Make sure that you're using the right authorization form. There is actually a Department of Health approved authorization form that the Office of Court Administration uses, and it has check boxes for HIV and mental health and alcohol substance abuse. And because of 3313 of the mental hygiene law and some of the rules that many of you have to follow, to share with someone that somebody has a disability or is receiving services from your agency, you really need that box checked. So it's really important that you use the right form when you're using an authorization so that somebody doesn't come back later on and say, this wasn't the right form, you didn't use it correctly. The other thing, and some of you who have had individuals in your organization lose lists of people you serve, which I know is a concern sometimes, and everybody now is in the room together. If you're in a room with someone from your organization, you're like probably laughing a little bit, but because it happens, right? Somebody loses their book or their folders or their pocketbook, and there's information in there about lists. If an individual is receiving services from an agency that is known as a developmental disability provider, the fact that they are receiving services discloses protected health information. I just want to give you a little bit, for those of you who haven't heard this prior, this is why. The way the courts have ruled on HIPAA is as follows. The fact that I was a patient at Albany Medical Center at some point, or Rochester General, wherever in the state you are, doesn't tell you anything about my diagnosis or my health status, because I could have been there for anything from blood work to deliver a baby to a stroke to a heart attack. You really don't know anything about, other than I was at Albany Med to get some service. But the fact that I receive services from a more specific organization where they do a very specific type of work, and it can be mental health, it can be developmental disability, it can be a cancer center. The fact that I'm receiving services there does say something about my diagnosis. And so the fact that somebody is receiving services from your agency is enough to disclose a person's diagnosis, and that is protected health information. So when you're thinking about, well, how much can I tell someone, it isn't a lot if you're trying to keep it to the minimum amount of information necessary. And then when you're talking about this employment relationship where you're related to the entity, your agency is related to the entity, how much information do you really want the for-profit venture to have about an individual? And with that comes concerns about the ADA, which Maggie can talk about a little bit later on. But within an organization, we often don't want to share information for fear that somebody will then use that information to make an employment-related decision based on it inappropriately. There is also concerns with redisclosures and concerns with staff. I could tell you stories for the next 45 minutes about all of the times that I get telephone calls about the staff at the PTA meeting, the random person who works at an agency who then discloses information in a public setting about somebody who receives services. And so the more we share information, and now don't forget, you're going to have people working alongside people that you serve who aren't used to being in an agency setting. The people that work for you, and I know that some of them are, you're less concerned with compliance than others. I'm sure you all have your favorite staff member in your head whose documentation frightens you, but the people in your agency are used to a certain culture of confidentiality. When you start venturing out and doing these other types of organizations, they're not going to have that same sensitivity to that. Many of your staff are either started with your agency or they're transplants from another agency that provides this type of service. They're very used to this idea of confidentiality. But now you're going to have people for working alongside in a very different setting where they might not have the same sensitivity to somebody's disabilities or somebody's issues. And if you disclose too much about it within that for-profit and then they run around at the PTA meeting and start talking about those things, that becomes a very, very big issue, and it becomes an issue of whether there's a breach. And so making sure that we're treating that separately as we can, very, very, very important, and something that you're going to want to think about. Because as you all know, you're only as good as your weakest link in compliance, and sometimes that can be particularly frightening. So, if many of you know that if we end up in a breach situation, breach is presumed now. That's the way it is. If somebody discloses information inappropriately, the breach is presumed, and unless there's this low probability that it was compromised, you're kind of in a situation where you ended up with a breach. So if somebody from your agency discloses information to your for-profit venture inappropriately, and then it gets out because you've got a staff member in that, in that venture that for whatever reason, you end up in this strange situation of whether or not there's a breach. And the problem is we can't guarantee what people are going to do with information. It's one thing when somebody loses their bag or their purse and we find it all intact. Then we can maybe perhaps say there was a low probability that something, was compromised, right? Because we lost the bag, but then when we got the bag back, everything was still in the bag. Now, you could argue that somebody could have ran to Kinko's or Staples and copied everything, but that's a little bit different. But when someone verbally discloses information about someone, like we've all played telephone, right, when we were kids, right, it just goes like wildfire. And it's very difficult to know where that information will go and how it will be inappropriately used. And those of you who have heard me talk about privacy before, Murphy's Law applies, which is at the PTA meeting, someone knows that family. It would be fantastic if, no one knew the person, but that is never what happens. If somebody says something inappropriate in a doctor's office waiting room, somebody who works with the person is in the waiting room. That's the way privacy works. So you've got to worry about those types of things, and you've got to be really sensitive, and you've really got to train your staff, because obviously you don't want to be in that position where you're notifying the individual, you're notifying their family, you're notifying the Office of Civil Rights, and you probably have dealt with a lot of interesting things in your own organization about protecting health information. You've probably went through a lot of efforts to make sure that you're destroying paper records properly, that you're doing certain things with your technology, that you're erasing them, that the copy machines are being wiped clean of their memory, all of those things that we talk about. You've done that in your agency. And encryption, right? You've become sensitive to the fact that you shouldn't be perhaps sending PHI unencrypted over a network. And now, to the extent that you're sharing any information, even with an authorization back and forth with your for-profit business, you've got to think about those things again. Because they have an email system, they have encryption issues. If they get information from you that has to do with someone's disability, or perhaps it's an exchange between you and a supported employment specialist about some things going on with the individual at work, and now they have that information, well, how are they maintaining it? Are they just throwing it in the waste paper basket? What are they doing? So even though they're not a covered entity, they're going to have your information. And I think one of the things that's interesting about this is if Wegmans does something inappropriate with that information, you have a supported employment specialist and they're dealing with the employer, and somehow the information gets out, nobody's going to affiliate Wegmans necessarily with your agency the same way that they're going to affiliate this organization with your agency. And so very important that we consider that as we go forward, because the breach notification rules, as many of you know, are all about public flogging, right? If it's 500 or more people, we have to tell the media. If it's 500 more people, we have to call the federal government immediately. If it's under 500, we tell them once a year all of the things that we did wrong. And so we really don't want to be in a situation where we're doing that. And I can guarantee you that if anyone ends up in a situation where with their for-profit business enterprise, they end up in some type of privacy or breach situation, I would bet 95 times out of 100, it's just going to be carelessness. It's going to be people not thinking. Because people in your agency are very used to freely talking about individuals and the services they're receiving, because that's what they do and that's what everyone in your organization does. This is a little different. This is a little different because we're doing different things, we're selling different services. We have this arm now of things that we're not used to doing. So all of the things that can embarrass you in your current agency, you got to worry about getting a little embarrassed in, this for-profit business venture, and you don't want to be. And just, the most common calls I get from agencies like yours across the state, the lost laptop, we leave stuff in our car, right? So you're in supported employment professionals, they're on the road, and they leave 3 of the folders of the individuals that they're visiting in the car, but they take the one in of the person that they're seeing, and then all of a sudden their car is broken into, and now 3 of the folders are gone. The ex-employee or employee divulging information to those outside the agency, or somebody decides that they're going to go work at your for-profit business. You have a really good employee and you decide that you'd like someone who understands what's going on, and you put them in your for-profit. But now they're not acting like someone who's in a for-profit. They're still acting like someone who was a service provider before. You can see people getting into a situation where they, too often disclose information or talk about it freely. The curiosity looks, the neighbor, right? Somebody's neighbor's on service or somebody's family member's on service. We can talk about email in a minute. Shredding, throwing out things. We have to sensitize people in a new business to these things that are very important to us, and obviously we've all debated encryption for a long time. So I share this slide, because yes, you need to worry about it in your new business, but please, for those of you who haven't done HIPAA reminders in a while or have been thinking about it, those of you who do compliance or thinking about it, some email tips of things that I see all the time. Do you have to reply to all when you respond to something? Because you know what happens? Somebody sends an email that says, do you want to go to lunch? And then people start adding people, do you want to go to lunch? And then everybody decides they're going to Panera for lunch. But the initial email exchange down at the bottom was information about an individual that's being served, or information about someone's struggle in an employment setting. But it turned into, do you want to go to lunch? And now we want 3 other people to go to lunch, and all of a sudden we've now spread that PHI around. We've had that a number of times. The groups, we have here group firm all, and sometimes we'll get an email that says, does anyone want to go to lunch? And it's from somebody in Buffalo, and Maggie and I are in Albany, and we would love to go to lunch, but we can't get there fast enough. So, those types of things, really scary when you're dealing with PHI, because all of a sudden it goes out. Checking the bottom of the chain. And I would say writing for publication. And I think people are going to be in this new for-profit venture, and they, again, may or may not have come from a healthcare or a human services setting. And we tend to, when I came out of law school, and I'll date myself a little bit, but we wrote nice letters, and we reread them, and then we edited them, and then we sent them to our assistant, and then they sent them back to us, and then we read them again. And since the advent of email and texting, we all put things in writing that we would have never put in writing before. We don't do it with the same care that we used to. And now you're going to be in an organization where people aren't even sensitized to that, to the importance of privacy. And so all it's going to take, and Maggie talked more about the labor and employment issues, but all it's going to take is some supervisor to make some backhanded comment about somebody's disability in, in an email exchange or something like that. I tell people all the time, there's still a use for the phone. Think about whether you really want to say what you're saying in an email. Pick it up. Pick up the phone if you have to, because you should be writing emails, particularly when in a labor and employment setting and others, writing emails as if everyone in the world is going to read them. And we're all guilty of it. We're all guilty of it because it's fast and it's quick and it's what we're used to now. But you've got to be very, very careful with those types of things. And then there's social media. So you all know the fear of social media within your organization. Photographs, pictures. My favorite story was the agency that called us to say that somebody had taken a picture of their desk and had posted it on Facebook and said, "Look how freaking busy I am." And that's funny. It was very funny because the desk was a mess, as some of our desks get sometimes. The problem was when you blew up the picture, as we can all do, and we can all save pictures off Facebook. Scary, but true. We all put up our kids anyway, but whatever. So when you blew up the picture, you could actually read charts. You could see names. You could see, information about the individual. And so now you're in a different setting. You're in a for-profit setting. You're not in the setting that provides services as much anymore. Much more common to just freely take pictures, to just freely post things. But do you get into a situation where somebody doing that ends up harming, and again, it's a for-profit business, but it's related to your agency, depending on the content of those posts, of pictures of individuals working, those types of things, is that a situation that you want to be in? And you may, again, not have people who are as sensitive to the issue as your current employees. Maggie will talk a little bit more about labor and employment issues, but as you set up your new for-profit business, you should just understand that email policies and disclosure of confidential information and confidentiality of internal investigations, which Maggie will talk about, these provisions that you see here on this slide are actually the ones that are under fire, if you will, by the NLRB. And you see the no photography rule is one of them, and that's because the NLRB has held that you should be able to take pictures and document and complain about working conditions. And so something that's too broad in a policy and procedure manual about some of these things actually may conflict with an individual's rights regarding their labor conditions. And so just as you're starting to think about what an employment manual might look like and how similar it is to your agency for your new for-profit business, you should know that these things are out there as well. And then obviously the way a lot of people see this unfolding, and there are many ways to do it, but one of the ways that we see this certainly unfolding is we're starting to see people say, well, this really is going to be a place where our supported employment professionals can go in and provide assistance, obviously, to these individuals who end up in whatever it is that we transform to. And it's an interesting time, I think, for that. And we all heard, I'm sure many of you heard Logan Troper's excellent webinars, and they talked about many of the things that we would highlight for you, including you heard us mention on Monday the boards and who's going to be on that board and do you have people competent. And they did mention audits and Medicaid audits, and Maggie and I could talk about them all day. But I think it's an interesting time because some of you, I think, experienced a struggle switching over to the new supported employment rules for documentation over this last year. And if you are not alone. Okay, you are not alone. It was a very condensed time period to really overhaul the way that is documented and billed. And it was a struggle for everyone. But as you start to see this unfold and as you start to project how these people are going to get into an employment setting and having more people maybe in a traditional employment setting, these issues and these hot spots for audits become very, very, very important. And here are some of the things that we have seen in the supported employment setting as people have tried to switch over to this. The 15-minute increment. No rounding up, and let me tell you something, there are many ways that you can end up in trouble with the rounding up. You can end up in trouble with the rounding up because your staff don't understand that they're not supposed to be rounding up. You can get in trouble with the rounding up just because people are not exact about the time that they are with an individual, and they don't quite know when they started exactly. And while it was really close to noon, I think it was close to noon, you can get in trouble there. You can get in trouble with the rounding up when you put everything into a computer program, but you're not exact with your numbers, or your computer program rounds inappropriately. So there's a lot of concerns about that, and that's the type of thing that can really throw your program into disarray from an audit perspective or self-disclosure perspective. And so people really need to understand that issue of not rounding up. You can combine time with individuals, but there has to be the same number in the group, because now the ratio of staff to individuals matter. And I know some people have said, depending on the setting that you're in, that can be very difficult. Some people, it's always one-on-one and it's very easy. But I know in some settings, in a community pre-voc or other settings, people are kind of coming in and out to see the individual, and that gets very difficult to document. So you really need to have a handle on how people are documenting. And if you don't know, you need to sit down with your staff and say, well, how are you handling that? Because that's the question that the auditors are going to ask if they have issues. And obviously there are limits on hours and months now, and that's hard, right? Is anyone keeping track of whether you're getting close to the cap? And where's the flag that you need to request more? And how is that going to work? Because we've seen that in many settings where all of a sudden you run over the number of hours that you're allotted, nobody knows enough to make the request for any more hours, and now you're billing, and then somebody realizes that you hit the cap. So, as we grow to more, more supported employment, more SEMP services, we're also trying to deal with the changes and making sure that there are a lot of pieces in that ADM. A lot of places. There's a lot of words, right? For those of you who have read the ADM, there's a lot of words, there's a lot of pages, there's a lot of bullets, and there's a lot of places where we can end up in a situation where we don't have enough documentation. And Maggie's going to talk a little bit more about investigations and audits and those types of things, but it's never pleasant even when it goes well, and so it's something that you want to make sure that you're making your best efforts at. Some of the new SEMP requirements, there has to be documentation that the person's making above minimum wage. That seems like probably a very easy thing, but for those of you who have dealt with audits, some of you have dealt with audits where they've looked at people's employment records, and there's just this one piece of paper missing. It's this one piece of paper, and we all knew it was true. We all knew the person had been appropriately tested for PPD, or we all knew that the person had met the MSc education requirements, but we don't have the paper. And so it's really important that when you look through that memo, that the paper in there is in your file. Could we be running around like lunatics trying to get that documentation later on? We absolutely could. I've joked with probably some of you on the phone that we'll just go over to the place that has the documentation and we'll sit there until they give us the piece of paper because we're undergoing an audit. But we don't want to be in that situation. You know, intensive services and extended services and the hours limits and all of those types of things and what's required. The billing for transportation time. There's a large section about that and the requirements and how that works, and it's extraordinarily important that your staff understands what's billable, what's not, what has to be done. And we're starting to see this increase in the allowance for billing for transportation in some OPWDD licensed services, but you have to be really careful that you have the documentation of that trip, as we would call it if we were in the ambulette industry. The ambulette industry over the years has struggled with this idea of trip tickets and what documentation you have to have of a trip, and how do you know that that particular piece of transportation was billable. You've got to be very, very careful that everybody understands and is on board as to what's billable and what's not. The certain staff training that's required. It's such an easy thing for OMIG to get you on, and they're just trying to do their job too, but it's such an easy thing for them to say, this training was required of staff, they didn't get it, therefore all of the services were bad. It's easy money. That is one of the easiest things, to find an individual who has certain credentialing requirements and then doesn't have the credentialing requirements, and then then obviously they shouldn't have been providing the services, so all of the services they provided should be paid back. That is very, very easy for them to do. Many of you saw it with the MSc training, right? The training that had to be done very early on in somebody's MSc career, or they had it when they were at another agency, but we didn't necessarily have the paperwork. So very important that you have documentation of that training.
I do have a question. I do want to. Oh, hello. Hi, this is Nicole. Nice. I do have a question that I wanted to bring up before you move along. And the question is, let's say a community business has a small startup in our building and is there often. They begin to make friends with people supported here, and it sounds like a good thing, integration, but they may share a name or a story that contains PHI. Mm-hmm. Will agencies using this business co-location model need to do a HIPAA training for business partners? Integration brings a lot of implications.
That's such a great question. Yeah. That's such a great question. Okay, so here's what gets really interesting. An individual that you provide services to is allowed to tell people anything they want to tell them about their own health. So I could tell you everything. It would be boring, but I could tell you everything. I have arthritis in my toe. I could tell you everything about my health right now, and that would be absolutely fine. So here we are. We're in a building. Individuals we serve may start to get to know people, and they may start to divulge information, and that's fine. What correctly gets a little bit murkier is when it's your staff that provides services, kind of bridging this relationship with this organization, and how much information we can share about individuals. Now, what's fine is a general conversation, I would say, about some of the needs of the people we serve. Here's some of the, but when we start to talk about Jack, or we start to talk about Jill, or we start to talk about specific people, that's when you're absolutely correct. It is PHI. We can do that with the permission of individuals who are interested in working there and think it's a wonderful opportunity, and it sounds like a wonderful opportunity. But we would want to do that, with permission, and we would want to then, you're absolutely right, sensitize the community business to the fact that this information is very sensitive and it is confidential, and we are under strict confines to keep it confidential. And personally, I think a training would be great best practice. Maggie, do you have anything to add to what I said?
Yeah, I do, and I do think a training is helpful.
Yeah.
Essential? Perhaps. I certainly think it is very helpful to sensitize the community business and the people that are working there. The case is very interesting because it is the case where I'm assuming the individual disclosed the information, and I'm assuming that may happen quite a bit with the individual disclosing certain things. But even if you have a defense by saying that the person disclosed it to me, it is just, I think, a real problem area. It's a hornet's nest.
Right.
How much was disclosed? How much should they continue to talk about it? Should that be a proper subject for discussion within the workplace itself, the for-profit or the business itself? So I think there has to be an understanding on the part of the community business and the individuals that work there that this isn't the kind of thing that should be discussed within the workplace, and they do need to be sensitized. Interesting just because I think the compliance function and the HR function have very similar kind of sensitivities, but there are certain things they're not sensitive to, and I think this is one of them. Particularly when people are freely talking amongst themselves and disclosing things and talking about things. So it is going to be interesting in my mind. I think a lot of this needs to be handled on a training basis with staff, and I think the sooner the better for these kind of trainings, and I'll call it sensitivity training.
Yeah. And I think, and one of the things is, you could see the individual providing people who work there a certain amount of information, and then you could see then them going back to a staff member that works at your agency and saying, hey, Jack approached me, and he told me, this has been his traditional, where he's worked before. We think we have a use for him. He's told me, these are some of his struggles. And it should at least make your staff uncomfortable enough that their eyes get big. Like, should I have this conversation with you? Should I not have it? Should I ask the question? So whoever asked that question, your agency's lucky to have you. That was a really, really good question.
And I have to just take it one step further. Families may get involved.
That's right.
And so that further complicates the issues. And I think even the individuals who might be disclosing it, I don't know exactly how you want to train them, but you may want to say, look, this is a different environment that you're dealing with than you were before. The individuals may not be as sensitive to the issues that you have. Again, it all depends, but it was a great question, and I think it's one that will come up quite frequently.
Okay, that was a great question. Thank you. The most interesting of the SEMP requirements, and I'm going to tell you why in a minute. Monthly summary note before the end of the next month. For years and years and years and years and years, auditors, both quality auditors and sometimes Omega auditors, have gone out, and when they've seen monthly summary notes that were beyond the end of the next month, they cited them, or they tried to cite them. And our clients would come to us and they would say, oh, it was not, September 30th, we did it October 3rd. And some of you in the room who have been part of these discussions would know that some of them are not October 3rd and they're 3 or 4 months late, and that's something a little bit different and a hard issue. But they're late. But they're late from what? Because there was no admin memo that included before the end of the next month. And here's the first one. So a lot of our clients that have said over the years, well, what's the big month, right? The big month is December. Because you got, when you have November, November services provided, and now it's December, and my goodness, I mean, if you don't get that note done right away, well, then it's the holidays, and then it's New Year's, and then there are days off, and a bunch of people are not in, and so, those of you who are familiar with documentation would absolutely say to you that in January, very often people come in at the beginning of January and say, oh no, we didn't do the monthly summaries, and now they're doing them at the beginning of the year. And so, but there was never that hard deadline this is the first ADM with a hard deadline, and we've had a number of clients come to us who have said things like, wow, this means there's at least the consideration of a self-disclosure issue when I run over that next month. And so very important, if somebody out there is in compliance and you haven't taken a look at SEMP in a while or whatever, now's the time to walk over there and see what's going on. And then I talked about ratios and hours, but the last one I want to talk about is the issues with the start and the stop time. A lot of people love to just start at 9 and end at 9:15, or start at 9 and end at 9:30. And if you start at 9 and you end at 9:30, that's fine. And I understand the beauty of things being round. I just want you to think a little bit like an auditor when you're looking at those types of records. And if your agency does it this way, don't panic, okay? Don't panic. Just think about it. Because an auditor in an interview process or an investigator, if you ended up in a Medicaid fraud situation, is going to say things like, you really started at 9 o'clock every day. Every day you started at 9. It was never 9:01. It was never 9:02. You always left at 9:15. How can we be sure that you didn't leave at 9:14? So there is an advantage to putting the actual time down that you started, because it really shows an authenticity to your records, and it shows that somebody is really taking that on not rounding up seriously. And an auditor, I think, is less suspicious of records that don't always say, I started at 10 and I ended at 11. Because that starts to look just a little bit like I'm just throwing the time down that I was supposed to be there, as opposed to, you know, the actual time. So that is my last comment. I'm going to kick it over to Maggie to talk about some more issues that come up.
Unless there's any questions, otherwise I'll launch into my slides at this point in time.
Did I take a breath? I think I did. Oh, thank you for the question. I got to take a breath.
No, we're all set. Go on ahead.
Terrific. I do healthcare and I do some employment. And you know, I mentioned how there are similarities between the two, but I do have to say, in a shift from a nonprofit to a for-profit and a shifting of a provider to really a business, you are going to have a lot of different changes. Changes in attitude, changes in your focus, changes in the mindset of the organization itself. The similarities are, for any entity, you're still going to be subject to a lot of regulations, the potential for audits, the potential for governmental investigations. They may be coming by different entities at this point in time than they were before, but they're very similar, and there are similar ways to deal with them, but there will be new challenges throughout this time that you will be faced with. I mean, we're just kind of highlighting what we think will be some of those. And so we'll go through the employment laws. There are so many changes that continue to happen with employment laws throughout, and there are changes federally, there are changes in New York State. There's been some significant changes to them even recently, which I'm just going to outline some of them. And you have the wage and hour laws. You have other laws that apply to employment. You have the anti-discrimination laws. And most importantly for our circumstances here, you have the Americans with Disabilities Act, which will probably come even more into play than before at a for-profit. I wanted to go through some of the recent developments just to highlight. And I will say, I think one of the changes here is that instead of the compliance officer, we're talking about the HR director. And I have noticed in working with compliance officers and HR directors, I think each one is very familiar with how important it is for them to keep documentation. I think they're all sensitive to privacy issues, but I will say that compliance officers really tend to be more thorough in their documentation of dealing with issues because they have to be. because of self-disclosure and audits. HR directors, on the other hand, I think are less likely to put things down in writing and have more conversations, more meetings, and so that is a little bit different. It's actually probably helpful in this regard because that is a change, and you have a change here. And some things, as Melissa had indicated, you don't want to necessarily commit to writing. And the HR directors, I think, are sensitive to that and are trained in that. One of the things I think that we just talked about, and I can't overemphasize, is the training of the workforce. The workforce who are going to involve many people with different disabilities, different capabilities, different really, I think, needs and how they can be accommodated. And for those people that have worked with those who are developmentally disabled, they may be used to it, but I'm assuming that you'll have many staff who are not. And so sensitivity training to those issues, training to just alert them of things that they need to be aware of, and to privacy issues, because many people in a for-profit may not be as in tune to PHI and those kind of issues. So I would think that training, and I'll call it sensitivity training, but it includes, going over all the different employment issues, especially discrimination, anti-harassment, things of that nature, I think is going to be very key when these businesses, or whatever their entities they are, start out. Because if you start out with having the mindset and training people in them, it will be a lot easier than trying to correct it after problems begin. Just wanted to mention some recent developments in labor and employment. In the first half of this year alone, there have been significant changes in terms of the hourly minimum wage change, New York State really leading the way with paid family leave, and then the new federal threshold for exempt employees. I also wanted to talk about the New York human rights law and some of the changes, although most of what you'll be dealing with, I assume, will include disability issues. Obviously, with your workforce, you'll have any kind of issue. And so any kind of protected category under the New York State human rights law obviously could come into play. Family status has been added to protected categories. Also, the New York State human rights law has been expanded and allows sexual harassment claims against employers with less than 4 employees. It provides attorney's fees for prevailing plaintiffs in sex discrimination cases. It clarifies that employers must provide reasonable accommodations for pregnancy-related conditions, and it includes gender identity, transgender status, gender dysphoria added as protected categories. Again, although we'll be dealing a lot with the disability issues, obviously, and as more and more employers know, just about every employee that you have could fall under one or more protected categories. And New York State is very protective, is very aggressive in their enforcement. Their Division of Human Rights, it makes it very easy for any employee to file any kind of complaint and to go forward against an employer, so you need to be aware. New York State minimum wage changes, those come into effect. It really depends on where you are, how many employees you have, etc. And then the New York State paid family leave, as of January 1, 2018, New York State will allow 12 weeks of paid family leave, and it's to bond with a newborn or an adopted child during the first 12 months of the birth or placement, provide for care for a family member, or because of qualifying exigency arising out of the employee's spouse, domestic partner, child, or parent who is on active military duty. So that paid family leave in New York will come into play a lot, could come into play, and often does come into play with your workforce. Also, there is a new threshold for exempt employees. As of December 1, 2016, there's been a reform and enhancement and a 3-year phase-in of the new threshold. Also, that threshold really looks at the classification of employees, and even if one might be considered or would have been considered exempt and non-exempt, they reclassify and they look further. So I'm sure your HR directors are trained in that, and those come into play. The biggest thing for you really is the Americans with Disabilities Act and the Human Rights Law. And this area of law really is expansive. Obviously, we're going to be dealing with individuals who have known disabilities and have actual disabilities, and many times have visible disabilities. That's not always the case in your other workforce. And I think with all those matters, you will have other staff who have to be sensitive to that, who have to watch what they're saying, and have to be willing to deal with different accommodations. And I do think that accommodations for one's disability will come up numerous times. And one of the things about the Americans with Disabilities Act and the Human Rights Law in New York is when they talk about reasonable accommodation, it is incredibly fact-specific. So even though one person may have the same disability, the way that an employer must accommodate them could be different for each and every individual. It's hard to deal with on occasions, and it's something that will be part of the new entity throughout, and something that the HR director will have to deal with. And one of the things that I've found with many HR directors is they want a bright line. It makes it easier. We all do. And we want an answer, or we want a knee-jerk reaction. And the bottom line is, when we're talking about disabilities, there usually is not a bright line. There's usually not a clear-cut answer, except for the fact that the law requires you to work with the individual, to have a conversation with that individual if they need an accommodation, and to reasonably accommodate that individual if they, in fact, can perform the essential job functions of their position.
Excuse me, Maggie, this is Nicola at NYSTRA. Just had a quick thing. The slides aren't advancing for some of the audience members. We see currently on the screen the SEMP requirement slide.
That could be my fault because I don't think I was doing it. Let me advance them. It's not advancing.
Pardon us, technical issues. Thank you to the attendee who wrote in about that. Yeah,
they're not advancing.
So if you click back on PowerPoint and click to the left. Oh, there we go.
Let's see. Thank you.
No problem.
I think now they are advancing.
Yes, they are. We see them. We are all set, and I'll let you resume.
Thank you. I include a discussion here as well about disability discrimination by association. I don't think you're going to have necessarily issues with that. And what do I mean by association? Someone in your family has a disability. the disabilities laws have been interpreted very broadly in New York State itself and federally. New York also has a New York City human rights law, and so for those of you within the city, you're subject to the New York City human rights law, and that has been interpreted even more broadly in many cases than even the New York State human rights law. That has allowed what is considered a disability to go to places that many of us never assumed them to go. In the case that I cite here, and it's not the actual name of the case, but it was a case that we handled in which an individual was claiming that they were discriminated against after being terminated for violating attendance policies because they claimed the termination was because the individual was dealing with their son who was allegedly disabled. What was the disability that the individual claimed? The son had a broken leg. And so they said the reason that they had been terminated was because they were dealing with their family, their son, and this disability. What did the EEOC say about that, and what did the individual say about a disability? First of all, an employee has to show that the employer was concerned about the expense the disability would cause, the possibility that the employee would become disabled in the future through association with that individual, or the possibility that the employee would become distracted by the disability. In the case where the son had the broken leg, they found that there was no probable cause and there was no evidence that the employer was concerned about disability. So they did actually dismiss the case. But we can learn from it, and I think a lot of things that we learn from it is disability, one, can be very broad. Two, really depends on the circumstances. Three, could depend on the evidence that you show about the attitude of the employer, which could mean anybody in the employer who has any kind of management position over the employee. So what do you take away from this? Well, before you want to terminate anyone or take any adverse employment action against an individual for alleged violations, in this case attendance violations, you want to make sure that the reasons are not related to an individual's disability or the disability of a relative or close relation. Here, in many of these cases, we're going to be dealing with individuals' disabilities and absences based on an individual's disability. And the takeaway is, one, was this the employer's concern, the disability, the continued I'd say risk of absences because of the disability, and did the employer take into account a reasonable accommodation for the individual's disability?
And Maggie, for our managers and supervisors and other people who are working at these new, for-profit entities who may come from, a more traditional setting, because you may hire a manager who knows how to run a cafe. I mean, that you would hope that you had somebody who had been in food service, but may not have had such a high percentage of their workforce be people with disability. I mean, you can imagine that if there were a number of people with a number of absences, it would be much harder to run that business. And so, I'm assuming that educating as to what the rules are and how much they can take into account the operations when they're making these decisions becomes very, very important.
It does, and I think absences is going to be one of the biggest issues that come up. And, we have the Americans with Disabilities Act, we have the Family Medical Leave Act, we have other leave provisions. We probably will have employers that have leave provisions in their handbooks. I think they're going to have to take into account intermittent leave, which will happen quite often with individuals dealing with developmental disabilities, and how they deal with that. And I think one of the things that comes to my mind is if you have someone, a manager, who is used to dealing with individuals not suffering from these disabilities, controlling even the comments they make, the stray comments. I can't deal with people who don't come in on time. I can't do this. Those little stray comments can lead very easily to a complaint that's filed, and a complaint that says the employer won't accommodate my disability. And in many of these cases, the employer will know of all these disabilities when, at the start of employment. So this isn't something that they can say, we didn't know about the disability. And because they know about that disability, they really have to try to accommodate. And so it really puts more of a burden, I think, on the employer to try to come up with a reasonable accommodation with the individual, and the employer in trying to educate staff who aren't sensitive to this in those kind of issues. So I do think it's going to be something that takes time and takes sensitivity. I also think it's something that will require documentation of when you try to accommodate, because you're going to know right away. Again, these are known disabilities, many times visible, but they're known. So you may be aware that this individual may need more time, may need certainly more time than what I'll call a non-disabled employee. So they will have to document that they attempted to accommodate, that they went to the individual, that they tried to work with the individual, and couple that with what you had, and that is family who was very used to being involved, and whether family might get involved in these kind of issues. In addition to the Americans with Disabilities Act, and it kind of goes with it, I think there could be multiple issues regarding harassment based on an individual's disability. And again, those are stray comments. Those are the use of certain terms that shouldn't be used in the employment context. And I think that's another thing. Again, the sensitivity training is going to be so helpful. So I'm gonna switch gears just a little bit and try to switch into government inquiries. But before I do, I know Melissa raised, and it's probably a whole hour, and I didn't get into it completely, but the handbook, the employment policies. You're all very familiar now with compliance plans and what you need to do with compliance plans and what they need to say. Handbooks go hand in hand with those, and I think that any entity that's created, any for-profit that's created, obviously has to set the tone in its handbook. I think it's important in its handbook to recognize that, to set the tone that we are an environment and an employment and workforce that is sensitive to all our employees' needs, and we don't discriminate against our employees based on anything. And obviously, all the handbooks say general things like that, but I think that HR directors need to focus on leave policies, need to focus on disability and those kind of things, and make it very clear in the handbook what is expected of employees if they need accommodation, what is expected of them in terms of notification when they're going to be out, or if they're at a doctor's appointment or whatever. And I think HR directors and other managers need to be aware, even when they're staffing things, of backup plans and having people there if they need a certain number of employees at one time and someone's out, because there will be more incidents of absences and really absences that you're not really going to have notice of, I think, more than usual. And so I think it would be best if, when these handbooks are being drafted and the policies are being created, that you recognize that in advance and try to deal with that. And I think the other thing that Melissa mentioned, and I think we can't avoid, is the social media. And she's very correct in that in your for-profit world, you have, your cell phone cameras out all the time, I think those kind of things can be dealt with in a very well-drafted policy, but again, we have some cloud over it with attack by the NLRB. So you do have to be careful, but I think they can be drafted in a way that certainly will be helpful to educating your employees and telling them what is expected of them. And one more thing, in the traditional employment for-profit setting, one of the things that you have a lot are evaluations and reviews. And those evaluations and reviews, I think, need to also be sensitive to the issues of your employees, most specifically here, the disabilities. And your managers need to be sensitive even in writing those.
And one of the issues also being that there needs to be a certain consistency in the way that you treat all of the employees, unless it's documented somewhere as to, you know, how one gets an accommodation. Because if you're unclear in your policies, somebody who doesn't have a disability could, you know, take that to mean that they are somewhat being discriminated against because they're being held to a different standard. And if you're not, you know, clear in how you develop those accommodations and apply those accommodations, you could end up in that situation.
You could, and I was even thinking that some individuals with developmental disabilities may not be as sensitive or as easily understand some of the issues that might revolve around other kinds of discrimination, whether it be gender discrimination. And so it will be a challenge, even in training. I think it would require and will require HR directors who are open and proactive. A lot of times, and I don't know how large all of these entities will be, but based on some of the challenges that we see, obviously I think most of you are sitting there going, well, we don't want it to be too big because it will be hard to control these kind of issues that come up. So it is going to be challenging. It is a shift, but the HR director has many of the same tools and skill sets that the compliance officer already has. And although it's a different, separate entity, you know, I do think that mindset will somehow transfer over. Government inquiries, you know, with any for-profit, you're going to be subject to any kind of government inquiry and audit. A little bit different, though, than what you had as a service provider. And to a certain extent, I don't always expect that there'll be the perhaps urgency of many inquiries, many government inquiries just relating for the for-profit as opposed to the service provider. You know, will be by letter, but you still have to be aware of the repercussions of the inquiries, your rights, and you always have to be aware whenever you're dealing with a government agency, regardless of who it is, whether it's the Department of Labor, etc., that you want to cooperate, but you want to know and have legal counsel present if you need to. Just like any kind of a compliance issue, you can't alter or destroy documents once an inquiry is commenced. You always want your staff to be aware. One of the things that we put in here, and the next slide, is the Justice Center. This was interesting because Melissa and I were talking about it, and we were trying to imagine the entity and whether or not the Justice Center would come into play here.
Would show up.
And you know, really their jurisdiction is not over a for-profit agency, but we can see, and I could definitely see that they mean the Justice Center, and we all know that the Justice Center is aggressive and is going to do what they feel they need to do to investigate. And I would imagine that in investigating certain individuals that are under their purview, they may have to interview some employees that you have at your for-profit. So there could be a situation in which the Justice Center does in fact come in and that the for-profit has to deal with that, which is really foreign for a for-profit. It's really taking that a step further. So I do put some slides in about the Justice Center and its aggressiveness and the fact that it's law enforcement and it does cooperate with the DAs, the police, and et cetera. I do want to just really focus on the fact that I don't see it happening too often. So unlike the individuals at the provider who obviously are very much aware of what their requirements are in terms of reporting and the hotline, you don't have that, you won't have that in the new entity, but you might need to deal with those issues if they're part of an investigation. I mentioned the Department of Labor, and I'm seeing an uptick in just audits and investigation by the Department of Labor, usually with wage and hour or unemployment, but we also have issues with workers' comp. And as with any governmental inquiry, often the source of the, or I should say the cause of the inquiry, can arise from complaints from employees. So you have a lot of similar concerns that you would have in terms of the audit functions from OMIG, from a different entity, but the bottom line even for that is they're all out to get money because that's what they're doing and that's what their enforcement is for the most part. So similar to how your staff is trained in responding to inquiries or even calls from OMIG or Mafuku or whoever, you similarly want to train them in if there's any letter relating to labor and whatever. It usually comes to management, so you don't have to worry about that. But one of the things that Melissa talked about in terms of time, I think would come up on this too, and whether or not you have time cards and whether or not you have people punch a clock. I think it's always best practice because it's easier, but those are the kind of things you'll want to think about. That is the end of my slides, but I'm happy to take any other questions as well, or Melissa, and we both can field questions at this point.
Okay, we do have a question from Dave Markey, and the question, I'm not sure the context, but it is, how could they, given that the for-profit business is not a certified setting? I'm going to unmute you, Dave, so you could ask your question aloud or give context.
Yeah.
I think he's probably talking about the Justice Center.
Yeah.
And whether or not, because the for-profit setting really should be under their jurisdiction. And we were envisioning whether or not they might have occasion to have to go into the for-profit to ask questions.
Right. Or they're looking for the individual perhaps to ask questions to, and it's during the day, and the individual's at work, and all of a sudden they show up, or there was some injury involved, and they're trying to figure out what was the nature and the extent of the injury, and so they show up at work and they start asking employees questions about well, did you see any bruising? Did you see those types of things?
Or did this person come late if they said it had occurred at a certain time?
Right.
And so we were thinking of those kind of things, but the question I think is correct in assuming that for the most part, right, the for-profit is not in the purview of the Justice Center per se.
Okay. If any other attendees would like to ask questions, you're welcome to raise your hand and I can unmute your microphone and you could ask your question aloud, or you're welcome to type more in.
One of my colleagues asked a question about a little about the HIPAA coverage, So a treatment provider is obviously a covered entity. A treatment provider, a payer, a healthcare clearinghouse are covered entities. A business associate is not a covered entity, but has a lot of requirements under the rules and under the contract. You could, I suppose, if you set it up as a parent model with the for-profit coming off the parent, if you decided that your agency was a covered entity at the top of the parent and everyone under there was somewhat covered because of that relationship, you could say your for-profit, I guess, was covered, but standing alone without that relationship in the organization, it would not be a covered entity because it would not be providing treatment unless somehow you decide you're going to provide, you're going to get licensed in that for-profit somehow, or you're going to have a not-for-profit that employs people and there's somehow some licensed services. What then is interesting is the information that is shared. So the information that is shared that comes with an authorization, does that make you a covered entity because you have that information? The answer to that is no. And in fact, employment records on their own are not covered by HIPAA. So the way to, which is, so in an organization, let's take an organization such as an agency that provides services, you have clinical records, which are covered. You have employment records, which are actually technically not covered by HIPAA. That doesn't mean don't protect employment records. It's very sensitive information, and there's a lot of good reasons that you should. But those records are not covered. So I always tell providers, treat that it all like it's sensitive, lock it up, do all of those things that you do. But the getting information, to help assist, or the information that's shared doesn't turn a business into a covered entity no more than if our law firm gets into a situation where, let's say somebody has to take an extended leave and has to provide physician information related to that, that doesn't turn us into a covered entity because that's employment information. So I know that's all murky and a little bit confusing, but it was a really good question.
Well, and the HR directors should know they keep the medical information separate from the employment information itself, so that if someone is looking at the employment file itself, they can't get all the medical information. They should only get that which is necessary
Absolutely.
for them. And for a manager does not need to know any of that for the most part. So I think you do keep it separate.
What you technically are, if you have that for-profit, that for-profit parent, or the for-profit under your not-for-profit umbrella parent, what you end up having is something called a hybrid entity, technically under HIPAA. And the way sometimes it's easiest to think about this is to think about your counties. So your counties have some departments that are covered by HIPAA. They have other departments that they've determined are not covered by HIPAA, and they kind of designate themselves as saying these are separate components. So your for-profit can be looked at as a separate component of your complete organization because it's not a provider of services. But that's somehow, to think about it. If right now everything you do is covered and you're thinking about, well, how can we have this thing that's not covered, that's the way it's done. So many times in like a county setting, the Department of Social Services, Aging, those are, but obviously there's a lot of departments that they operate that don't have protected health information, and they don't want to train everyone in HIPAA, so they designate them under this hybrid entity provision in HIPAA. Okay, now that's highly technical HIPAA and boring. So
and I guess I have a question to follow up. So should the for-profit entity staff be trained in HIPAA or not?
I think they should be trained in the sensitivity and confidentiality of information. I don't think they probably need a full-blown HIPAA training. They don't need to know what an accounting is or what, individual access rights there are or any. They don't have any of that information. But when we're talking about divulging information, that they learn as part of their employment that's sensitive outside the organization, it's probably a scaled-down confidentiality training that's probably best practice, but not a full-blown, HIPAA training.
Yeah, I would agree, and I think that's just a smart kind of training to do?
You know, no different in all honesty to, you know, our law firm received some training related to, you know, related to an individual that had a guide dog, and we didn't, you know, we would not have known. I mean, I think we would have all went to pet the guide dog had we not received the training. So in certain settings, it's good to give people a sensitivity that they might not otherwise have.